Hello and welcome to today's WorkSafe Month webinar, The Management of Mental Health Issues in the Workplace, the Legal Perspective. I'm Stephanie Morawski from WorkSafe Tasmania and I will be your moderator. Before we start, please take a moment to read the following slide about information received today. I'll now go over housekeeping. Here is a screenshot of the attendee control panel. You should see something that looks like this on the right hand of your screen. You're likely listening in using your computer's speaker system by default. If you would, however, prefer to listen over the phone, just select telephone in the audio pane and the dial-in information will be displayed. Webcams and audience microphones will not be used in today's webinar. Questions will be taken at the end of the presentation. Please use your control panel to type and submit your questions. Finally, today's webinar is being recorded. I would now like to introduce your presenters, Luke Taylor and Sarah Seeley, partners in HWL Ebsworth Lawyers Hobart office. Luke deals with workers' compensation and other safety matters, while Sarah practices in the area of employment and safety. Welcome, Luke and Sarah.
Good morning, everyone. As Stephanie said, my name is Sarah Seeley and I'm a partner at HWL Ebsworth in our workplace relations team here in Hobart. And my colleague Luke Taylor, who's co-presenting today, is a partner in our workers' compensation and safety teams. Thank you for your virtual attendance today. Whether you're in the office or in your home office with a hot drink, we're really pleased to have the opportunity to present to you on this important topic on the management and investigation of mental health complaints in the workplace. It's a topic that frequently comes up in matters we deal with for clients, and it's one that can be particularly challenging. And in our post-COVID, inverted commas, new normal, we're also seeing a real spike in these issues and the related challenges, particularly managing them remotely. These issues tend to highlight as well the intersection between safety, human resources and workers' compensation elements, and it can be a complex interaction. Everyone here today has different backgrounds and skills. Some of you primarily practice in human resources, some in safety, some in workers' compensation. So some of you will be familiar with parts of this presentation and not others, and vice versa. So we're here to share our knowledge with you and to try and bridge that gap, but it's also, as Stephanie said, an opportunity to ask questions and share your experiences. So please do that through the control panel as we go, and we'll address those at the end of the presentation. But to place this all in context, why are these issues so important? Why do we need to think about them so carefully in terms of how we investigate and manage mental health challenges in the workplace? There are really four key reasons. The first one is the blunt lawyer response, which is that you have to. The law imposes obligations on you to manage these issues in a certain way. And if you don't, you can incur legal liability both on the part of your employer and in some cases personally. So it's therefore critically important that you know the scope of your obligations and how to conduct yourself within the law. Second is obviously the commercial context. So not managing these issues or managing them poorly will cost you. It can be a direct cost and it can also be indirect. It will cost you time and it will cost you money. And that can occur at both ends of the spectrum. So there's a potential commercial cost arising from lost opportunities to recruit and retain talented people. And there's an actual financial dollar cost to the business if there's legal action and you have to defend litigation. Thirdly, we know employee morale and productivity can be affected, and there are a myriad of studies on the impact of workplace culture and managing employee issues badly. And we've all seen this in practice and the impact it can have on productivity, and that can be enormous and very difficult to unwind. And in contrast, managing these issues well, even when serious issues do arise, can have a really positive impact. And fourthly, of course, your obligations as employers under the Work Health and Safety Act to provide and maintain a safe workplace. And we'll look at that duty in more detail shortly, but for the moment, suffice to say that your duty to provide a safe workplace and safe systems of work is situation specific. What I mean is you can't overlook or ignore the impact of illness or injury, including mental illness, of particular workers when in meeting your obligations. So it makes good legal and financial sense to invest some time in understanding or in refamiliarising yourself with what your obligations actually are with respect to ill and injured employees, and to put in place some sensible strategies for managing the issues appropriately. But how much of an issue is it really? Safe Work Australia has published statistics that tell us that it's estimated a GP who sees 40 patients a day can expect to see between 8 and 10 patients requiring support for treatment for anxiety or depression. Mental health problems are the third biggest health issue in Australia, following heart disease and cancer, and around 45% of Australians will experience a mental health issue at some point in their life, with 1 in 5 Australian adults experiencing a mental illness in any given year. To put that in practical terms, a total of 3.2 days per worker lost each year through workplace stress and stress-related illness. And we know that stress-related workers' compensation claims are on a significant increase. In relation to psychological injury claims, work pressure accounts for about half of all of those claims, and a quarter of those harassment and bullying in the workplace, sort of making up those psychological injury claims. Preliminary research tells us that Australian businesses lose over $6.5 billion each year by failing to provide early intervention and treatment for employees with mental health conditions. So the impact is huge. A mental health claim has potential safety, human resource and workers' compensation implications, but often we'll see clients either not recognising the safety aspects of the mental health allegations or failing to deal with all of those three intertwining elements effectively. And whilst things can be done really well on one side, if there are issues on the other, it can result in significant claims and costs. So today we're endeavouring to bridge the gap and to make us all more comfortable with managing mental health issues and complaints in the workplace. In terms of the legislative framework, there's a whole range of material that impacts on how we investigate and manage mental health issues in the workplace in Tasmania. The main statutory provisions are summarised on the slide. Most of these obligations will be familiar to us. The challenge really is how to apply them in practice, in the reality and the mess of actual life situations, but more importantly, how they operate and interact together and what to do when they conflict. For example, if you have a Fair Work Act complaint in relation to a protected attribute in a discrimination matter that also is touched by a workers' compensation claim and may involve an anti-discrimination element as well, each of those pieces of legislation have different procedural requirements and different potential outcomes. So it's understanding all of the red flags in each of those pieces of legislation and how they might interact. Safety, workers' compensation and human resources. We all appreciate that there's an intersection between what they do. Gone are the days, if indeed they ever existed, where you could approach a matter as purely a human resource issue and ignore the safety elements or the workers' compensation consequences or vice versa. What happens in one sphere will often impact the other, and Luke and I certainly find that's routinely the case in practice when managing client issues. Simple examples might include an improvement notice issued by WorkSafe may impact how you're managing workers. A stop bullying application may give rise to a workers' compensation claim, and you often see those two going together. And there may be something systemic that sits behind the stop bullying application that needs to be dealt with from a safety perspective. Conduct that may justify disciplinary action in an employment or human resource context may not absolve you from your obligation to provide suitable employment under a return to work process in a workers' compensation claim. And again, that's a fairly common scenario. So before we commence our detailed discussion on how to manage and investigate claims, it's important just to take a step back and have a think about how these issues arise. What are the typical triggers for a mental health incident? And what is it that typically causes these issues to arise and escalate, requiring human resources to step in and manage the situation? The main triggers are summarised on this slide. Each of these give rise to potential safety, HR and workers' compensation obligations. And in the context of employment, the data tells us that mental health injuries are often recorded to be caused by excessive time pressure, so unreasonable deadlines, poorly managed organisational change, redundancies, poorly provided support in those changing contexts, conflict between people, and that's obviously a huge and consistent theme, interpersonal conflict, harassment, bullying claims, exposure to occupational violence and aggression. WorkSafe publishes a range of data about Tasmania specifically, and that tells us that 90% of serious work-related mental health condition claims are due to work-claimed mental stress. Harassment and workplace bullying and work pressure account for over 60% together, over 60% of serious mental health claims in Tasmania. And each mental health injury claim results in incapacity of over 60 days absence from work. In Tasmania, healthcare and social assistance workers report that the most mental health injuries in 2018, and nationally the occupations most at risk are Defence Force members, firefighters and police, so first responders, followed by school teachers. I just want to turn now to the Work Health and Safety Act, initially due to the umbrella framework it provides. So in terms of the legal framework, the relevant legislation here, as we know, is the Work Health and Safety Act, and it imposes some overarching responsibilities that I want you to bear in mind as we discuss every other topic that we're going to go through today. It really is in many senses an umbrella piece of legislation that establishes the outer framework for every other duty and responsibility we're going to examine. So everything else we talk about today will fit inside the broad general obligations imposed by this Act. We've been living with the harmonised regime nationally for some years now, and I often still refer to it as the new Act, but it's been around for a long time, but many of us will recall that under the former OH&S Act, the primary duty was imposed on an employer who was obliged to take all reasonably practicable steps to ensure the health and safety of its employees. We know that under the harmonised Act, that obligation is significantly enlarged, and the primary duty is now held by a person conducting a business or undertaking, or a PCBU. And every business represented here today is a PCBU. And as you'll see, the definition is broad. It includes businesses conducted for profit, as well as charities and not-for-profit businesses and organisations regardless of their legal structure. The only relevant exemption to that, which may crop up from time to time, particularly if you have roles serving on boards, for example, is some volunteer organisations. But this exception will only apply if you don't employ any staff. So as soon as you employ someone, regardless of your status, you're covered. So every business here is a PCBU. Your primary duty, as you're no doubt aware, is to take reasonably practicable steps to provide a safe and healthy work environment. Non-compliance with this duty carries serious consequences, including potential jail time and financial penalties of up to $3 million. Non-compliance can also be a criminal offence, so very serious consequences. As I mentioned earlier, the obligations imposed by the Work Health and Safety Act are situation specific, and that means you need to think about your employees as individuals and not as a homogenous group. What might be a safe workplace for an able-bodied employee might not be safe for someone else. So similarly, an employee who is ill or injured or suffering from mental illness may need extra assistance or support as compared to an employee without that predisposition, illness or injury. So in order to comply with the Act, you need to know about the abilities and disabilities, skills and limitations of your workforce as individuals, and this includes mental health issues. Looking at these obligations in the context of mental health issues specifically, the primary obligation includes a duty with respect to mental health. So in order to meet these duties, you have to do a risk assessment to identify the hazards and the risk factors in your particular workplace and to implement controls to manage those hazards and risk factors. There's a range of data available, and the WorkSafe website has some great links to tools on risk assessments, as does Safe Work Australia. But it's about gathering workplace data, so examining your sick leave records. Can you identify patterns? having a look at workers' compensation claims. Are there hotspot areas? Are there complaint hotspot areas? Look at your organisational policies, for example, around harassment and bullying. What is the uptake? What are the outcomes? It's your direct observations, walking around the workplace, informal conversations with employees. They're the best source of data. They know what's making them stressed or causing them issues, and they usually have some ideas about what can be done to address those issues. In larger organisations, you'll often see employee surveys, pulse surveys, to ascertain whether or not, and they're often anonymous, whether or not there are hotspot areas within particular groups of workers or across particular sectors that require attention. Currently, under the legislation, there's a clear duty on employees to report hazards. So the employee has an obligation to report, and the employer has a corresponding obligation to investigate any hazards reported to them and to inform the employee of the results of the investigation. So typically, an investigation will be required in order to meet the primary duties under the Work Health and Safety Act. There's also a clear duty personally imposed on officers to take reasonable care to ensure that the PCBU has the systems and processes in place to ensure that information in relation to incidents, hazards and risks is considered regularly and is responded to in a timely way, including with respect to mental health. So in order to meet this duty, a PCBU will have to investigate mental health issues that arise. And as I said, there are a number of really useful online tools on the WorkSafe Tasmania website and also on Safe Work Australia that can guide you through, that have been developed in conjunction with the ANU and talk about how you might implement them in different sized workplaces. So what are these psychosocial mental health factors? And we need to take account of them from a safety perspective. So there are really three categories. We've touched on some of these already. They're organisational, environmental and individual, and you need to be across all three of them for your specific workplace and for your particular employees or workers. There are three risk factors that contribute to work-related stress and mental health issues, and these are together called the psychosocial factors. So the first one, organisational factors. These are ones that can be controlled at an organisational level. These are about managing work demands, autonomy and control, so the amount of authority a worker has over the way they do their work, the level of support that the worker receives from management and colleagues, role conflict and ambiguity. This is another key trigger point for these types of claims, and obviously that's the extent that the employee's tasks and duties are clearly defined. So we see this lack of clarity as a massive organisational factor for stress claims. People like to know and have clarity around their role and the certainty and security of their role, and in the current environment that's particularly key. Relationships is another big one, and this is the eternal issue in interpersonal conflict. So the extent of good working relationships in the workplace, the presence of bullying and harassment, identifying those issues and addressing them. Change, which touches on role conflict, so planned and unplanned change in the work environment, so individual changes to position and responsibility, or takeovers, restructures, redundancies at the larger end of those change factors. Rewards and recognition is a positive factor, so involving rewarding employees' efforts and contributions and achievements within the organisation. And organisational justice, which refers to perceptions about fairness and work procedures and how they're enacted. So this is what people think about how things are done in your organisation, and procedural fairness and relationship fairness. Environmental factors. These include physical and chemical stresses, noise, temperature, vibration, air quality, those sorts of physical elements. Guidance about factors related to environmental factors is often contained in codes of practice and guidance notes. They're again available as a resource from WorkSafe Tasmania. The individual factors come down to knowing about your particular worker. So thinking about how different individuals will respond to work-related factors, and including their individual ability to cope and their personality factors. And it's important to note that individual responses to stress do not reduce employers' legal liability and responsibility to minimise exposure to work-related stress. There are a number of factors that predispose individuals to having a higher stress response. Being a new employee, being a young worker, being in a vulnerable class of worker, having an existing disability, injury or illness, having previously been exposed to a traumatic event or other workplace trauma, workers who are currently experiencing difficult personal circumstances outside of work, because obviously there's an interaction there in terms of what their reaction may be to work-related stresses. So obviously not all of these psychosocial factors are within the control of the employer or the work environment, and there are a range of those individual factors around their ability to cope and other personality factors that we can't do too much about, but we need to focus on what we do have the ability to control, and when we're aware of individual factors, providing as much additional support or accommodation as is reasonable to manage those individual factors. So we're just going to have a look, because it's really useful to look at these things in a real world context. We're going to have a look at a scenario where, a case example where this might arise. This is John's scenario. John is a trainee accountant with ABC Accountancy. He's studying, he has a young family, he has a mortgage. He was recently moved to Glenda's team. Glenda is technically excellent, but she's new to managing people, and this was key to her promotion to her new role. Glenda does not have any experience in supervising employees, and several people have already left the team that she manages as a result of her supervision style, and this has created even greater demands on the remaining team members. John has been with the business for several years, but he's finding Glenda temperamental. He feels that Glenda is never happy with anything that he does, and that she criticises John in front of other workers. John feels increasingly anxious and uneasy at work. He's fatigued and finding it difficult to sleep. And he's becoming increasingly withdrawn from the rest of the team. Glenda does not know about work-related stress and mental health issues in the workplace, and she fails to recognise the signs. The organisation does not have a risk-assessed approach to managing work-related stress or psychological injury. Eventually, John boils over and is now on work-related stress leave. He's been diagnosed with anxiety and depression, and he feels unable to go back to work. So how do we manage a safety investigation into these issues? I'm going to hand over now to Luke, who will talk through the steps arising from this scenario.
Thanks for that, Sarah. And just before I continue the presentation, likewise, I'd like to thank everyone for joining us today and participating in this webinar. So Sarah's just spoken to us about John in his role with ABC Accountancy in the particular situation that's arisen in relation to his employment there. From the safety and mental health perspective, I'll talk about the safety investigation and the requirements of a safety investigation in the context of John's case. I'll then talk about implementing controls following and as a consequence of the safety investigation. I'll then briefly touch on the pitfalls of not conducting a safety investigation, or at least conducting a safety investigation to a suitable standard. We'll then revisit John's case in terms of the outcome, having conducted the investigation and implemented our controls. And then I'll move on to the workers' compensation component to what we're talking about today. As indicated at the outset of today's webinar, workers' compensation is sort of my area of concern. So we'll fold that into the discussion just to sort of see what the implications are when a workers' compensation claim is made. So just coming back to John's case and ABC Accountancy, the situation has arisen that Sarah's just spoken about. John's boiled over, or the situation has boiled over for him. He's been diagnosed with anxiety and depression. He's now on work-related stress leave. What does the business do? Well, it engages a safety investigation, and we can see on the slide there the key elements to that safety investigation. From the business's point of view, the PCB's point of view, It's looking at the circumstances that gave rise to the complaint and whether there are any psychosocial factors that may have given rise to the complaint which the organisation can control. It's not really about whether there is merit in the complaint. Now, there's other processes that might deal with that particular issue. Of course, if a workers' compensation claim is made, merit might well be a consideration in that regard. But in terms of a safety investigation, we're taking a sort of a more high-level look at the situation and the causes of it to arrive at the outcomes that we want to reach. So in that regard, the focus is on whether the organisation can do something to remove the circumstances which may have led to the complaint, regardless of whether it has substantive merit. What will actually be required for the safety investigation will depend on a number of factors, such as what is reported, how many people report it, the type of allegation, and the internal safety and HR procedures of the organisation. Suffice to say, some investigations can be simple and some can be much more involved. What the organisation does do will nonetheless have to comply with its own HR and safety policies. It is prudent and would be prudent to develop a specific psychosocial investigation policy which sets out what is required and what the triggers are for each level. Steps are to identify the contribution and source factors and controls and preventative factors that can be put in place as summarised on the screen. This will enable the business or the PCBU to implement risk control measures to eliminate work-related stress so far as reasonably practicable. If it isn't reasonably practicable to eliminate the risk of work-related stress, then of course the aim becomes to reduce that risk so far as is reasonably practicable. Risk control measures should target organisational and environmental factors specific to the workplace and the specific circumstances of individuals to be effective. And of course, Sarah earlier touched on taking into account the specific circumstances of individuals within the organisation. Review and revise risk control measures to ensure that they address the organisational factors that may have contributed or may contribute to work-related stress. Risk management of work-related stress should be undertaken on an ongoing basis. When changes occur in the workplace, for example, we've introduced some new processes, we've introduced new supervisors, these should be reviewed to determine whether there is any unplanned adverse effects on employees. So we've decided to establish our safety investigation. What's the framework around that? What are the nuts and bolts considerations? It's not much different in terms of what is required for evidence from other types of investigations you may have conducted. Critically, you need to be aware of making assumptions and base any findings and conclusions in the investigation on the facts. The incident details need to be examined. The notification of the injury, review incident and accident reports. Ask yourself the questions: what was the issue? How and why did it arise? What was said and done? How was it said and done? Is there any evidence about the employee's complaints, their demeanour or their presentation? Again, touching on individual idiosyncrasies and individual presentations. What was the vulnerability of the worker? Are there any prior behaviours, issues or injuries which might have raised flags? If the injury relates to a specific event, remember the 5 W's of any investigation: who, what, when, where and why. Where did it happen? Who was present? How did it happen? Again, establishing and trying to ascertain and identify the relevant facts. For more significant investigations, evidence needs to be corroborated, contemporaneous, documented and signed wherever possible. Statements might need to be obtained and minutes of meetings, correspondence relevant to the issues in dispute might need to be reviewed. Again, isolate assertions from the facts. That's absolutely critical. Be specific in your findings about who did or said what and in what order, who was working with the injured person, who instructed and or assigned the job if that's a relevant consideration. Keep the inquiry and the investigation confined. Keep it confined to individuals, places and events. Be clear about what your objectives are with respect to the investigation. Consider relevant policies and procedures, including any codes of conduct that the organisation has in place. You'll see there the 4th dot point relates to medical evidence. You might relevantly determine that you need to obtain evidence from a counsellor or a nominated treating medical practitioner that the worker is reviewing. You can seek, if relevant, commentary regarding pre-existing conditions and or prior injuries. And of course, the key word there is relevance. You might seek independent medical opinion. Now, in a scenario where, for example, there's been a commensurate workers' compensation claim arising out of the same circumstances, of course, the workers' compensation insurer, or if the organisation is a self-insurer, there might be a different component of the business dealing with the workers' compensation claim. An independent medical assessment might be scheduled and might be arranged for the worker through the workers' compensation process. I'll touch on the intersection with workers' compensation soon, but the critical point to make here, and I'll keep coming back to this, is that be clear in understanding what the information being obtained through a workers' compensation medical assessment might be versus what you might be trying to obtain in terms of facts and information through a safety investigation. Those two things don't always equally align. And of course, outcomes can very much depend on the information that's obtained. And then, of course, we have other evidence in 2020. There's a lot of online material, there's social media, there's surveillance if there is a performance or a disciplinary element to the mental health situation. And just coming back to John's case, what might have caused his work-related stress? In the example that we've given of ABC Accountancy, Sarah spoke about the background facts giving rise to John's situation. He'd recently been moved into Glenda's team. Firstly, we have a change of team and a change of manager. As a result of a number of people leaving the team, that left the team short-staffed, and there was an increased workload on John. So secondly, increase in work demands. Sarah spoke about the difficult relationship that John has with Glenda, so a poor manager relationship, and he feels that he is not recognised for the work that he does, so a reward and recognition issue. The team is understaffed, so John needs to pick up the other tasks, and he's not always 100% sure about what he's required to do. So we have that role conflict ambiguity with John not being sure how to perform his tasks. And he also feels that he has little control over his work, so there's an autonomy control issue as a result of perceived controlling style of his supervisor, Glenda. John's work-related stress was not initially identified or dealt with, and the result was work-related stress leave for anxiety and depression. So if that's the findings that we've arrived at through the safety investigation that we've conducted, that takes us to implementing our controls in terms of the business's response to the situation. The first level of controls are our primary controls. Safety obligations require you to implement these high-level controls first and to rule them out as not being reasonably practicable before you can implement lower-level controls. There's nothing preventing you from implementing controls from a number of levels at the same time, but this is most certainly a starting point. As we go through examples of each level of controls, you'll hopefully see that much of what is required from a safety perspective you might already be doing in response to human resources or workers' compensation claims, but you need to document that it is also being done to control safety risks. These primary interventions, and there's examples of those on the screen, are preventative. The goal is to reduce the nature of the stressor before employees experience stress-related symptoms or disease. They target stressors at their source, such as the organisation of work and working conditions. Level 2, secondary controls. These are ameliorative. The goal is to help equip employees with resources to cope with stressful conditions. They target employee responses to stressors. So in a sense, they're much more individualised than the level 1 controls, which are more organisational based. And again, there's examples of these secondary level controls on the screen. And then thirdly, the tertiary level controls. These are reactive. So in other words, we've already got the situation on our hands that we need to deal with. Goal here is to treat, compensate and or rehabilitate employees with enduring stress-related symptoms or disease. They target enduring adverse health effects of stressors. And again, there's examples of various level 3 measures on the screen. And of course, much of that, or some of those examples, there might be interaction and interplay with third parties such as workers' compensation insurers, given the responsibilities that those third parties might have given the particular scenario. So, for example, return to work programs, that's a responsibility in terms of the management of that of a workers' compensation insurer. But of course, as a PCBU, as an employer, there'll be a part to play with respect to return to work programs as well as those other tertiary measures. So what happened in John's case? Well, because it was managed so well, we had a great outcome. John eventually returned to work. In terms of some of the implications and steps and measures put in place as a result of managing the situation so well, Glenda contacted John with HR support. This was because there's emerging evidence that early and regular contact from managers during a sick leave absence is associated with a more rapid return to work. Sarah spoke earlier in the presentation of some of the statistics in terms of mental health claims in particular, and the impact, the economic and financial impacts, as well as the personal impacts of those things. My take is, with the work that I do, it's pretty well understood culturally just how significant managing mental health claims is, and that early contact and continuing and consistent contact is can be absolutely critical. Glenda was unaware of the impact of her supervisory style on her team and was provided with training and coaching support. So equally, a very important step to take as a result of this scenario. So we come back to our level 2 control of providing leadership development for Glenda. She now regularly meets with all members and has members of her team, has recognised the need to provide more positive feedback and allow each team member to have more control over the way they perform their work. And finally, a return to work plan was developed to support John's return to work in conjunction with HR, and eventually he returned to his previous role and the team is functioning well. So a good news story. Business developed a risk assessment and an organisational-wide approach to managing work-related stress. So just to pause there, we've rolled out of the acute immediate level 3 response to the scenario in relation to John, level 2 response to the scenario in relation to Glenda and where she fits in the organisational structure. And having been through the experience, we're now starting to roll out and implement those primary level controls in terms of organisational wide initiatives. HR started monitoring absenteeism and other data to look for trends and potential hotspots within the business. ABC Consultancy provided all employees with mental health awareness training, partially to destigmatise mental health issues. Workplace policies on bullying harassment issues were developed and implemented. So, as I've said, this was all a good result in the end. But what can happen if the investigation was not managed so well? There's a number of pitfalls involved in conducting safety investigations. The first pitfall, I suppose, is not conducting one when the business should do so, given the circumstances. There can be reasons why businesses and organisations don't conduct safety investigations when perhaps they otherwise should. Some businesses, for example, might only be reactive when there's a formal WHS incident. Other barriers, of course, can include when the employee that's involved or is at the centre of the situation doesn't participate in the process, and that might mean the process doesn't get off the ground. There's other pitfalls in this space. So if we do have that workers' compensation claim on foot, a lot of businesses can make the decision to take that step back and allow the insurer through its process to conduct the investigation into the incident. And that picks up on, the issue I should say, and that picks up on what I said at the outset, which is that the insurer might well have particular objectives that it is attempting to achieve through the investigation process. It might be geared towards obtaining certain factual matters, certain evidence, certain information that doesn't allow the business, if it is made privy to the results of the investigation in the first place conducted by the insurer, doesn't allow the business to properly and fully assess what it ought to do in response to the safety investigation. And then that takes me back to those controls that we've just spent a few minutes talking about. And not identifying the contributing risks adequately. That can be a consequence, of course, of allowing someone else to conduct the safety investigation for you, or not conducting an adequate investigation yourself. And of course, that doesn't allow us to identify preventative measures adequately. Just to step away from John and ABC Accountancy, just for 1 second, I've got a real life case to discuss just quickly in relation to an inadequate investigation conducted by an employer. This is a Queensland case. It involved the Director of Nursing for the Cape York Health Service, Ms. Robinson. She alleged that she was subjected to repeated managerial mistreatment by the Health Service's CEO, which caused her to develop a psychiatric injury to the extent that she was unable to return to work. The Queensland Supreme Court found that the Health Service had breached its duty to take reasonable care by failing to take timely and determinative action on complaints made against Ms. Robinson by an employee and by Ms. Robinson against the same employee. By failing to investigate complaints or failing to find the complaints were vexatious, the CEO and vicariously the Health Service allowed the issue to cause conflict, uncertainty and humiliation within the workplace. The court found that given the risk of serious psychiatric harm was reasonably foreseeable to the Health Service given Ms. Robinson's concern about the complaints against her. Notably, the court commented that a reasonable employer would have considered that its response to complaints bore heavily upon the probability of injury occurring to its employees. Now, in that case, Justice Henry stated as follows: in an era when the potentially grave psychological harm done by workplace harassment and bullying is well known, unjustified blaming, humiliation, belittling, isolation, undermining and contemptuous disregard of an employee by a CEO was conduct collectively raising a foreseeable and not insignificant risk of psychiatric injury. Now, in the result, the court awarded Ms. Robinson damages of just under $1.5 million, including general damages and damages for past economic loss, loss of superannuation and future economic loss and expenses. Now, of course, in terms of an award of common law damages, it's very much dependent on the plaintiff's circumstances. So I'm not suggesting that any Supreme Court case in Tasmania is going to result in an award of damages of just under $1.5 million, but there's certainly the potential there for that adverse finding in that particular scenario. That brings me back to the point I was making earlier. In some cases, it might be someone else is investigating the matter, for example, an insurer or a claims agent. But the insurer's investigation most likely is not looking at the systemic issues and recommend controls, which might be very, very important, not only for the present case or the case that you're dealing with, but of course in relation to other employees. Relying on someone else's investigation is likely to seriously hamper you in terms of properly understanding the issues being able to respond to them in the ways that we've discussed today. It's a business risk. So Sarah's spoken about obviously the impacts on the individual and also the people that work with the individual in the form of their colleagues and their managers and so forth. But there's a business risk element to it as well. And of course, we can see some of the steps that can be taken by the regulator in relation to psychosocial claims. Interstate, and I'm sure I'll be subsequently corrected if the situation is different for WorkSafe Tasmania, but certainly interstate safety regulators have specialist inspectors appointed to investigate psychosocial allegations. They issue improvement notices requiring a full psychosocial risk assessment to be conducted and controls to be implemented and investigations into complaints to be undertaken. Safety prosecutions for psychosocial issues are now a reality, although as far as I understand it, there haven't been any prosecutions in Tasmania to date, but certainly there's been some interstate activity for some time now. And I don't think from a cultural perspective, my day-to-day experience is that anyone would be surprised if in an appropriate case in Tasmania there was a prosecution under the Work Health and Safety Act of a PCBU that failed its primary duty of care for failing to provide a safe place of work for a worker in circumstances where those psychosocial factors were at play and there was some level of responsibility and criminal responsibility by the PCBU leading to the worker suffering that mental health injury. Now, workers' compensation, of course, this is a significant issue and in its own right in relation to mental health injuries. Just a quick snapshot, I suppose, for those who are attending today who don't have a high level of familiarity with workers' compensation in Tasmania. Firstly, it's a no-fault scheme. So a worker can make a claim for compensation under the Act, which is the Workers' Rehabilitation and Compensation Act 1988. And they don't have to establish fault or negligence in their employer in order to obtain those statutory compensation benefits. In the context of a mental health injury, it's an invisible injury. It can be problematic for employers, to use the word in the workers' compensation legislation. It can be problematic for employers to really understand the scope and nature, and particularly the cause of a mental health injury. And oftentimes the question of perception is raised. So in other words, this other worker wouldn't have reacted to the same way to this new program that we've implemented, so therefore it's not reasonable that this is a legitimate workers' compensation claim. I'll deal with that issue a little bit later. Is it just a work-related injury? Are there other stressors potentially at play affecting a particular worker? It's a huge issue. In my day-to-day practice, I see a lot of mental health-related workers' compensation claims. Sarah spoke earlier about some of the statistics on the WorkSafe Tasmania website in relation to mental health claims in the workers' compensation context. 90% of serious work-related mental health condition claims are due to work-related mental stress, work-related harassment and or bullying, and work pressure are the most significant causes of mental health issues, which account for 60% of serious mental health claims in Tasmania. There's also a statistic in relation to loss of time in the context of mental health claims for workers' compensation. Again, in my day-to-day practice, I don't see, I'll rephrase that, I regularly don't see people going back to work soon after a mental health type claim. They can be very complicated to disentangle. Obviously, the working relationship, depending on the cause of the mental health claim, can be compromised. In Tasmania, we have a preliminary dispute process under Section 81A of the Act. So effectively, from the date the worker has made the claim for compensation under the Act, the employer has 84 days or 12 weeks to dispute liability for the claim. If they don't dispute liability within that 84-day time frame, effectively they're taken to have accepted liability for the claim. So there is a sense of an adversarial approach right from the word go when a workers' compensation claim is made in Tasmania because of that dispute mechanism. But of course, in the mental health context in particular, being adversarial is not always the best approach. And there's anecdotal and empirical and evidence as well as studies in terms of the outcomes linked to disputing workers' compensation claims as opposed to taking a more conciliatory approach, a more communicative approach, less litigious approach. Just that last point on the slide is one that comes up very regularly. Certainly, I'm asked quite often by employers about whether they should continue human resources processes which are already in place at the time the workers' compensation claim is made. That is a very tricky, can be a very tricky dilemma. Of course, the HR process was already in place. There might have already been a performance management process in place. There might have already been a disciplinary process in place. And in fact, those things might have been ultimately the cause of the workers' compensation claim being made. Your starting point there is the worker's certification for work. If they're totally incapacitated for work, then they can't logically participate in any continuing HR process. And in the mental health context, I suspect you would need to be fairly careful of continuing any HR process, particularly the more serious the process was, for a worker that was even partially incapacitated or fit for suitable duties, as I say, in the context of a mental health injury. The running on the workers' compensation claim, particularly if it's in that initial 84-day period, will quite often be taken by the workers' compensation insurer. So the key message there is work and communicate with the workers' compensation insurer as to the approach they're taking with respect to the claim and understand the steps they're taking, what potential implications of the steps that they take and how that winds in and ties in with any HR process that the business is undertaking. Excuse me. Just a little bit of workers' compensation 101. In Tasmania under the Act, we have an injury, and the definition of injury includes disease. A disease means an ailment, disorder, defect or morbid condition, whether of sudden or gradual development. And the definition of injury also includes the recurrence, aggravation, acceleration, exacerbation or deterioration of a pre-existing injury or disease where the worker's employment has been the major contributing factor to that recurrence, aggravation, etc. The critical inquiry from the workers' compensation perspective is the point at which the worker is incapacitated for work by reason of the disease. Those of us that operate in the workers' compensation space take it as second nature that when we're talking about a mental health injury, a mental health condition, then we're dealing with a disease for the purposes of the Workers' Compensation Act. Another question which quite often gets raised in this context is, does the worker have to be suffering from a recognised psychiatric diagnosis? They certainly don't have to identify in their claim form that they have a recognised psychiatric diagnosis. There's plenty of case law in the workers' compensation space in Tasmania to the effect that the worker just needs to give notice or proper notice to their employer as to the nature of the injury that they've sustained and in relation to which they're seeking compensation. So 9 times out of 10 when I see, excuse me, when I see a workers' compensation claim form for a mental health claim, it'll say stress and anxiety. Stress in and of itself, strictly speaking, isn't a formal psychiatric diagnosis, but 9 times out of 10, that'll be what the worker puts on their claim form. That's still a legitimate claim because inevitably there'll be some medical evidence in the form of the medical certificate from the doctor or subsequent medical reports. There'll be medical evidence backing up there is a psychiatric diagnosis. Even if there's debate about whether there's a formal psychiatric diagnosis, that doesn't necessarily invalidate the claim. However, that said, and this is often a query that's raised by employers, the worker's reaction being a mere emotional response or frustration or emotional upset might not qualify as a disease for the purpose of the workers' compensation legislation. And of course, if there's any queries about that, it might be a case for legal advice to the workers' compensation insurer. I spoke earlier about perception. There's a legal principle, of course, which I'll assume most people are probably familiar with, of the eggshell skull, and in the mental health context, we have the eggshell psyche. So just because 9 out of 10 people wouldn't react to a certain scenario arising in the workplace with the development of work-related stress, and that might manifest in a psychiatric or psychological condition, but a 10th person out of that group of 10 does develop the condition, it's no defence from the employer to say, well, these other 9 people didn't develop any condition arising from those circumstances, so it's not reasonable that we should have to compensate this worker. You have to take, in the workers' compensation context, your worker as you find them. So if a particular individual responds to a scenario in a particular way, there's no defence to saying that a percentage of other people wouldn't have responded in the same way and developed any condition in the circumstances. Typical psychological injury claims, industrial accidents, and then that second dot point there with the sub-points, it's really that psychosocial element that we've spoken a little bit about today. Industrial accidents, of course, we see the PTSD type result from quite serious traumatic events. Of course, what's not particularly mentioned on screen there is there can be secondary psychological consequences from physical injuries as well, which I suspect is probably a topic for another day. But certainly the focus is on that second dot point today of that interpersonal or employment-related dispute scenario, and we see some of the real-world examples there of when psychological client claims might arise. For those of us that work in the workers' compensation space, we're reasonably familiar with the defences in the Workers' Compensation Act to claims made on that basis. That sits in section 25(1)(a) of the Workers' Compensation Act. And effectively, it's all about reasonable action taken in various contexts by the employer, as long as that reasonable action was also taken reasonably as well. So there's a dual test of reasonableness required in relation to the conduct of the employer. And that's often a path that the workers' compensation insurer in particular will go down for those psychosocial claims. Again, it will investigate the background circumstances of the claim with a view to ascertaining whether that dispute under Section 25(1)A of the Act can be taken. Again, that doesn't always sit in perfect unison with the PCBU's responsibility for the safety investigation. Key takeaways from the workers' compensation side of things. Regrettably, this slide was obviously written by a workers' compensation lawyer. I would say, firstly, communicate with your worker. They're the most critical person in the whole scenario. But of course, just or of similar importance is communicating with the insurer, because as I've raised a couple of times today, their imperatives through their investigation process and the way that they handle the workers' compensation claim for mental health might not sit comfortably with the objectives of the organisation that we've spoken about earlier today. Be clear about what your objective is as a PCBU, as an employer, and have clear plans in place to achieve that objective. I'll hand over to Sarah to finalise the presentation.
Thanks, Luke. And thanks, everyone. I'm conscious that we want to have some minutes for questions at the end. But I just wanted to wrap up by looking at HR's role in conducting investigations. And really this applies to management as much as human resources. It's that unique role in terms of oversight of the whole process and managing that intersection, which we've gone through in terms of safety, workers' comp, and the industrial relations, human resource issues. And whilst you don't have to be across, you don't have to be subject matter experts in all of these areas, it's critical that you understand the intersection and that you have enough information to manage red flags when they come up. Because management and HR are also going to be important gatekeepers in terms of what feasibly can be done, in practical sense, what can be changed. HR have a key role in determining how the investigation will be run. Can it be resolved informally? Will somebody saying sorry resolve an issue? We can often see that things can be de-escalated if prompt action is taken. Should it be privileged? This is an important consideration if you want to keep an investigation out of anticipated legal proceedings conducted under legal professional privilege. You do that by engaging lawyers early and the investigator will work to the instructions of a lawyer. And that could be an internal lawyer or an external lawyer, but that has to usually occur from the commencement of the investigation. Also needing to ensure that someone is responsible for supporting and managing the participants. What if the complainant is not at work? And this happens a lot. An employee might say they're suffering from stress and they're unfit for work, but that doesn't necessarily mean they're unfit to participate in an investigation. And in fact, they may want to actively participate to convey their concerns. So again, it's this case-by-case consideration. Some ideas might be having a telephone conversation with the employee to ask if they feel up to participating in an interview, and dealing with how the business could support them through the process, arranging for the interview to be held off-site, going back to who you choose to investigate, so thinking about who the employee may feel more comfortable with, providing them with EAP and support, etc. Understanding the limits of the investigation that might be dealt with in your internal policies and procedures. We are seeing complaints about process and procedure more and more, so understanding your own internal policies and making sure they're sufficiently flexible. Not just what if the complaint's against one of the decision makers. Those things are difficult to manage if you don't have enough flexibility within your own policies and procedures to deal with those types of elements as they come up. What's the right outcome? Safety often want to find causes so they can fix them. Human resources know that sometimes those causes can't be fixed because employers are limited by the legislation and a reasonable accommodation from an equal opportunity perspective, for example, around reinstatement. And the problem is that a dismissal under the Fair Work Act has a whole range of, it might be unjust because there's not enough evidence, the investigation doesn't come up to a standard that would provide cogent proof. It may be harsh or otherwise unreasonable. And because reinstatement is the primary remedy, you can sometimes find yourself back where you started. Just to round out, it's really ensuring, there's no right way to do this, but procedural fairness is critical. So the participants are entitled to know and understand what the allegations are. They need particulars and they're entitled to those. They're entitled to an adequate opportunity to respond to the allegations. They're entitled to a support person. Ensure that your own procedures and policies are being complied with. Ensure that investigators and decision makers have appropriate training to conduct the investigation, because again, procedurally is really an element where we're seeing a lot of challenge to these. The investigation's done, a decision's made, and the investigation is picked apart in subsequent litigation. So you do have to be on the front foot from the start. So it's an opportune time to review your safety and HR procedures and ensure that they do address mental health elements and that they're sufficiently flexible. Conduct an audit of your own internal skill set, identify gaps for investigators and decision makers, and upskill those people if that's required. And finally, ensure that your systems are sufficiently robust and capable of being adapted. As we've sort of seen and gone through, real life is complicated. These things can get really messy. So really you want the flexibility in your documents, because there's nothing worse than being straitjacketed by an outdated policy that you're stuck with because you haven't updated it or otherwise dealt with it. Sometimes it's better to have, almost better to have nothing than something that really hamstrings you in a process, or it's an inappropriate process that by its own definition is open to attack by the Commission or in court. So have a look at what you've got in place. That rounds us out.
Okay, thank you, Luke and Sarah, for your presentation. So we'll now take questions from the audience. So please use your control panel to type and submit your questions to today's presenters, Luke Taylor and Sarah Seeley, partners in HWL Ebsworth Lawyers Hobart office. So a question, Luke and Sarah. How should an employer obtain medical reports, not just medical certificates, and when should this be done? Does the worker have the right to say no? This sounds to me like it's a legal process.
Yeah, that's right. Often you'll get a scenario where you might get a series of medical certificates, or there's a concern raised because of the length of time that a person is having off, and you're entitled as the employer to query, and it's always a bit of a fine line. When does that become unreasonable, and when are you entitled to question further? And that's really a balance of what is this person's role? If they're constantly unwell or away, do we have sufficient concern to say, look, we need to know more about this problem before we can be satisfied that you're safe to return to work or to perform the inherent requirements of the role. Often, medical condition may have nothing to do with their ability to perform the role, depending on what it is, or it may be highly relevant if it's a physical job, or if there's some other element that the employer considers they need information about to return that person to work. So initially, I would always recommend commencing with discussion with the employee about their period of time off work. And if you don't have, often you'll see built into an employment contract a right to seek further information, or even to refer an employee to what's called an independent medical assessment, which is the second step where you want independent information about that employee, that particular worker's ability to perform the requirements of the role. And you might see that on a return to work scenario, but it does happen in other more generalised periods of absence. The Fair Work Act allows employers to terminate if somebody has had up to 3 months of sick leave, whether it's explained or not. So there are legal levers you can press, and you do have a right to assess, and it comes back to your safety obligations as the employer, to assess whether that person is a risk to their own health and safety or the risk to health and safety of others in the business. And that's generally when those things are challenged, it will look at, was it reasonable for the employer to do that? And it's a case-by-case assessment of what information the employer has and the role the person performs, and how they go about getting that information. It's a good question. It comes up a lot.
Thank you, Sarah. And just further to that, would not the worker need to give consent to obtain their medical information, their private medical information?
So if there's a request for medical certificates and say it says, you know, Sarah Seeley will be absent for the next 4 weeks and it's just for a medical reason, and we say, well, we want to know a bit more about that reason and I refuse, then unless the contract has a specific requirement or ability for the employer to seek medical information from the treating doctors, then that can be difficult because the employee says, well, no, you're not entitled to it. But what the employer can do is control the return to work from there. So you might not necessarily be entitled to the information at that point, but you say, well, that's fine. But if you're taking 4 weeks off and we don't know what the problem is, we have a legitimate concern about your ability to return to work, and you deal with it at that end, at the return to work end, around sufficient information, and you get a consent if you can, or you otherwise seek an independent medical assessment and you say, we won't be returning you to work until we have sufficient information for us to satisfy ourselves that it's safe to do so. So that's why often the time involved becomes, you know, what's reasonable, what's not. So a couple of weeks or a week is usually not going to be sufficient. But if it's a pattern that you can point to as the employer, then that can provide a basis for the request.
Stephanie, can I just chime in?
Go ahead.
Just chime in from the workers' compensation perspective in relation to both of those questions. So again, let's take the scenario that the worker has made a claim for workers' compensation. The workers' compensation legislation has provisions within it that can require the employer, and in this context, when I say the employer, it's really the workers' compensation insurer that's managing the situation. From the employer's perspective, there's provisions in the Act that can require attendance at independent medical assessments with respect to the injury, and of course, issues like capacity for work, treatment, and so forth are all relevant parts of those assessments. But coming to a fitness for work question, which is the concern for the employer on an ongoing basis, again, the questions that the workers' compensation insurer might ask of an independent specialist might be different from the types of questions that the employer needs to have answered in terms of assessing the worker's ongoing fitness for work. So again, if you do have that workers' compensation claim situation, if the insurer is sending the worker off to independent medical assessments, you need to understand the types of questions that the insurer will be asking, because the responses might not provide you with the information that you need from the employer's perspective to properly manage the return to work and fitness for duties and so forth. Just to consent to medical records in the workers' compensation context, the claim form, the workers' compensation claim form, includes a medical authority, which I would say most people sign, probably once or twice out of every 10 claims I see, probably the medical authority is not completed. Of course, that's a voluntary choice by the injured worker when they make their claim. The records, or the authority, only extends to records or medical records which are relevant to the injury, which is the subject of the claim. You can't go back into historical irrelevant medical records. But there's also a mechanism under the Act if the medical authority in the claim form hasn't been completed by the worker. There's provision in the Act, section 90A, which says that if you're sending a worker off to an independent medical assessment to their workers' compensation claim, then they're deemed to have given consent to their medical records being disclosed to the independent assessor.
Thank you, Luke and Sarah. Another question, should you contact the employee if the claim is against you? Could that potentially cause more stress for the employee?
Is that, well, I assume that might be in relation to if a bullying complaint is made against you and you're the manager. Again, look, yes, that can cause more stress, and it has to be carefully considered in the context of, can it be quickly dealt with if it's a sort of a misunderstanding, a scenario that you can, the relationship can be repaired, or depending on the nature of the complaints. And again, this is why I talk about flexibility in the procedures. And I recently had a matter where the complaint procedure was, there was one person who was the complaints handler, and that person, a complaint was made against. And because the policy was so inflexible in that sense, it caused a lot of problems within the organisation around, well, how do we how do we remove this person who the complaint's been made about from the process? And so someone more senior within the organisation, and it might even go up to board level, has to step in and should be designated, and that should be planned so that everyone's on the same page about who will be the liaison. And if it's someone who's preferably got a pre-existing good relationship with the complainant, that can be of great assistance. But you've really got to look at fact and degree for each matter and each worker and try and set out a plan, a communication plan really, that's going to give it the best chance of an early resolution.
Sarah, I would add to that, there's, and again, you're absolutely right, it's dependent heavily on the size and resources of the organisation, of course, but if it's a case where, for example, a smaller organisation and there might be not a great number of people that could approach the worker, there's a lot of, I guess, third-party providers that might assist you, workplace facilitators and workplace moderators. Might they have a role to play?
Yes, yeah, absolutely.
Thank you, Luke and Sarah. What can you do when your HR person is the main cause of a bullying claim or poor communication and work pressure?
Yeah, again, and this is sort of similar to the previous question, because the person around who should be managing the issue effectively is the issue, and the staff can find that really difficult to navigate. So often they're the types of issues that have the real potential to be a bit sort of a ticking time bomb, because often you'll find that there's a large amount of difficulty that's probably got a bit of a long tail in terms of its history that hasn't been addressed because the very person that could address it is part of the problem. So again, and it's dependent on your resources. And as Luke said there, you can bring in external conflict coaching, for example, or, you know, if that needs to happen. But it might also be looking at that HR person in terms of their own performance and their performance in the role and managing that separately to how do you address these complaints. And that would obviously need to exclude that person from that process entirely, usually going up the chain to a senior manager, CEO, board level if you have to make sure procedurally that there's enough clear air that there can be no taint on the investigation. Because as I said before, often what we see is an investigation occurs and then the process that's adopted can be open to attack, either because the person who the complaint's about is somehow involved or privy to information. And whilst that might just have a perception and there might be no real issue behind that, it's often enough procedurally to knock the process over.
Thank you, Sarah. Is there more information that the audience could look up in respect to the case relating to the $1.5 million payout?
Yes, that was just a result of a Google search that I ran. So the parties involved were, the plaintiff was Robinson, and the employer was the Cape York Health Service. So it's a Queensland Supreme Court decision. If you just Googled Robinson, Cape York Health Service and Queensland Supreme Court, that'll return the result.
Thanks, Luke. Can an employee make a claim after they have been made redundant?
By claim, do we mean workers' compensation?
Yes, yes.
Yes, yeah. Any the ongoing nature of the employment doesn't. Sorry, I'll rephrase. If the employment comes to an end, that doesn't stop a worker's ability to make a claim for compensation for facts and circumstances which occurred within their employment which led to their injury. There are time limits which apply to the making of claims. Oh, there's a couple of obligations, I should say, under the Act. The first is that the worker has to give notice as soon as practicable after the occurrence of the injury and before they have voluntarily left their employment. They have to give notice of the injury to the employer, and of course we're talking about a redundancy scenario which might not necessarily be voluntary. And then the other requirement under the Act is that any claim for compensation with respect to an injury has to be made within 6 months after the date of occurrence of injury. So certainly make the claim in theory after a redundancy, but mental health claims, as I said before, we treat them as diseases for the purposes of the Act. The date the disease occurred, which is a concept in the Act, can be a bit problematic because it's effectively the date the person is certified as it's the date on which they're first incapacitated by reason of the condition or certified as being incapacitated by reason of the condition. When it comes to a mental health injury, of course, that incapacity can happen quite a deal later after the events which give rise to the condition fomenting in the can be very much a case-by-case judgment. Straight answer to the question, it is possible for a claim to be made after redundancy.
Thanks, Luke. Another question, do the actions undertaken by the employer in managing workers' comp claims and safety investigations fall under safety responsibilities as PCBUs?
Sorry, Stephanie, I just had a little audio issue there. Could you just repeat that question for me, please?
Absolutely. Do the actions undertaken by the employer in managing workers' comp claims and safety investigations fall under safety responsibilities as PCBUs?
I think the answer to that is yes, and that picks up, I think, on basically Sarah's earlier point or first point in relation to the Work Health and Safety Act. That is the umbrella, the way that we characterise it. The Work Health and Safety Act and the obligations falling under that is the umbrella under which all of these other responsibilities and functions that employers or PCBUs have. So workers' compensation, other safety matters, discrimination, all those other things fit within that work health and safety umbrella. Now, of course, compliance with the law, for example, compliance with requirements of the workers' compensation legislation, compliance with anti-discrimination legislation and so on, is a relevant consideration in terms of assessing compliance with the Work Health and Safety Act.
Thanks, Luke.
Anything to that, Sarah?
Sarah, did you want to comment on that?
Oh, sorry, I had a bit of beeping feedback. No, look, I agree with what Luke said, and the only thing I would add is that if you are managing, for example, a workers' compensation claim or an anti-discrimination claim and you're complying with that legislation, that won't necessarily discharge all of your obligations under the Work Health and Safety Act, because the Work Health and Safety Act will examine what's reasonably practicable, not just what complies with other legislation as to what an employer should be doing in certain circumstances.
Okay, thanks. Just to remind everyone as well, sorry, Sarah, just to remind everyone that that this webinar is not intended to be legal advice and should definitely not be relied upon as such. So just a scenario that has come in, Sarah and Luke, which you may wish to respond to. So what would happen in the case where a staff member has a mental health diagnosis, has had considerable time off, and it's now starting to impact on staff? The organisation, has been reasonably, flexible and understanding. Sort of where does you sort of draw the line before there's any sort of repercussion to potentially cut this employee's role?
Yeah, look, that's a really good question, and it's a scenario that comes up reasonably frequently. So you've got someone, you've made some accommodations, always indicating that they're temporary. For example, if it's someone's on reduced hours or they're otherwise unable to perform all of the requirements of the role. The difficulty in this type of situation is, whilst the employer obviously wants to be supportive of the worker, the injured worker or the ill worker, you also have obligations in relation to your other staff. Often this sort of scenario puts a lot of pressure on remaining team members, and that can result in flow-on impacts there, but also primarily, can this person, the injured person, ill person, perform the requirements of the role on an ongoing basis? And the employer is entitled to query that, particularly after a lengthy absence or illness. And that would commence with inquiries with the employee around their treating doctor. And often you'll find in these types of claims that there'll be some return to work support. You can engage a return to work coordinator, even absent a workers' compensation claim. And often through that process, it will become apparent that the person either is or is not improving to a point where they're able to recommence in their primary role, their substantive role, so not their modified role. And if they're unable to do that, then you can move to a termination on the basis of a failure to perform the inherent requirements of the role. And that involves an assessment of the medical evidence that you have available, and you're entitled to seek an independent assessment on those grounds.
Thank you, Sarah. So we just got 2 more questions that will get you both to answer. So if, for example, an employee has been off work for a long period of time for a mental health issue, they've lodged a workers' comp claim which has been declined, but they continue to provide medical certificates on a monthly basis that they are unfit for work, at what point can you look at terminating the role if there seems or appears to be no intention to return to work?
Is this in the context of a workers' compensation claim, or are we talking, if we're talking just generally an employee failing to return to work or lobbing in medical certificates, then the Fair Work Act requires that after a person has been ill or absent for a period of 3 months, you can move, that's an exemption for an unfair dismissal claim if you move to termination on those grounds. Often when that process starts to occur, there'll be a flurry of activity and perhaps a workers' compensation claim at that point. But my view is always that these things should be pressed ahead, and that employers should be able to action these types of scenarios without, as long as things are done lawfully, then there shouldn't be a consideration or a concern about other claims that may come in, because you deal with that as it arises, and you have to manage this employee scenario just as much for your other workers and culturally to show that you are going to address these issues as they arise, balancing the support of the worker. And then if there's just no intention for that person to return, and that's quite clear, then you can look at termination under the Act, which also includes abandonment of employment provisions sometimes come into play if that person isn't responding to requests or doesn't appear to show, or without reasonable excuse, so doesn't have a medical certificate or isn't returning to work at all. There are a number of levers under the Fair Work Act that can be engaged after that 3-month period.
Thanks, Sarah. So just
Stephanie, just from the workers' compensation perspective, I think the scenario you read out was that workers been off work for quite some time with a mental health condition. They had made a workers' compensation claim, but it had been disputed.
Or the claim has been dismissed.
Okay, so that's a really critical point, because ultimately is, can you start a termination process if that's the decision and the grounds exist, obviously subject to, picking up on what Sarah said, really, really important point under the workers' compensation legislation, because an employer is required to keep open or make available to the worker the employment that they were engaged in immediately before they became incapacitated for a period of 12 months from the commencement of that incapacity. So, in other words, reading that very broadly, you need to keep their job open to them for a year after they've become incapacitated, except that provision in the Act does not apply if the claim has been disputed under Section 81A, and that's that 84-day process that I spoke about earlier. That provision to keep the job open for 12 months does not apply if the claim's been disputed.
Thank you, Luke and Sarah. So we'll now close today's webinar. So thank you, Luke Taylor and Sarah Seeley, partners in HWL Ebsworth Lawyers Hobart office. And thank you everyone for attending today's webinar, The Management of Mental Health Issues in the Workplace, the Legal Perspective. Once you do leave today's webinar, you will receive a short survey to complete. We do appreciate you providing us with your feedback. Today's webinar has been recorded and will be made available on WorkSafe Tasmania's YouTube channel. On behalf of WorkSafe Tasmania and the WorkCover Tasmania Board, thank you for joining us, and thank you, Luke and Sarah.
Thanks, Stephanie.
Thank you.